All right, this is part one of a two-part first series for our new YouTube channel, BPS Bites, where I provide kind of snack-sized tips and tricks to help folks understand and comply with Washington's Clean Building Performance Standard and Seattle's Building Emissions Performance Standard. The goal here is to help folks understand the law so we can comply with it and ultimately move towards decarbonization, because that's what we're all after. So this part one, we're going to talk about the history of specifically Washington's Clean Buildings Performance Standard. And then in part two, talk about what is the law, what actually are the elements of it, and sort of like what's next. So here in part one, we will get in a little bit into the difference between a statute and a regulation and state rulemaking authority, so bear with me, and basically how state agencies are delegated certain authority to do things like create, modify, and amend rules, which are then codified into Washington's administrative code. Right, those are our regulations. Here in Washington, we have state statutes, the Revised Code of Washington, and state regulations, the Washington Administrative Code. That sort of cadence is very common in states. State agencies, also commonly, are authorized by the state legislature to do things like adopt certain rules. These are usually pretty technical things, like in this case, adopting EUI targets and other very specific aspects of building performance, like exemptions, penalties, etc. So what's the timeline, right? So if we go to 2019, House Bill 1257 was passed and codified in our Revised Code of Washington, specifically 1927A, I think 200 through 240. I'm also not going to try to hide the fact that I'm looking at notes because there's a lot of details here. So bear with me. So it was codified, that's what the term that we use, in our state statutes and related to commercial buildings, initially 50,000 square feet and larger. That bill, 1257, the original legislation, gave the Washington State Department of Commerce, which is one of many state-level administrative agencies, what we call the rulemaking authority to establish a state energy performance standard for covered buildings. And it specifically dictated that that standard had to use ASHRAE Standard 100 as the initial model. So we all now know and love ASHRAE Standard 100. It's our best friend with the modifications that Washington has specifically added, which I'll get to in a minute. It is common for state legislatures to delegate these types of things, as I said, to administrative agencies. There's a process for doing this. Every state, including Washington, has an Administrative Procedure Act that sort of governs how this moves forward. I'll bore everyone to tears if I explain that, but that's kind of how this whole process works. State administrative agencies, like the Department of Commerce, have these, as I said, legislative, adjudicative, and enforcement functions, and agency regulations have to be sort of specifically delegated by the legislature, because otherwise that's the legislature's job. If they're going to hand it over to a state agency, it has to be kind of specific as to what needs to be done, and it was in this case. So that original legislation said that by November 1st, 2020, the department must establish by rule a state energy standard for covered buildings, and that was done, right? So that's 2019. By 2020, we had to have the EUI targets. Now, fast forward to 2022, we had Senate Bill 5722, which is also known lovingly here as the expansion law, which expanded the scope of covered buildings to the scope of legislation, I guess, to smaller buildings and multifamily, which we now affectionately know as Tier 2, and added to the existing statutes and established Tier 2 incentives. So it made some revisions and additions to the existing statutes in Washington. So that was 2022. Now fast forward 3 years again, 2025, House Bill 1543, which is top of mind for every building owner and operator here in Washington State, that was adopted, and it further amended those existing Washington statutes and with some key revisions to the existing law. So the bill was really enacted to give building owners greater flexibility by authorizing Commerce the ability to do a couple of things. One, grant extensions, which we hadn't seen before, and added things like additional exemptions and compliance pathways. So a focus on increased flexibility and compliance. It's typical for the legislature to do things like this, to kind of take a look at, assess what's happened, and then direct the relevant agency to do some specific things. That's what happened here. We'll get more into this in part two. So as of May 2026, as I'm sitting here, we are currently proceeding through the rulemaking process for House Bill 1543. I will leave a link in the comments to more information about that, or link in the caption, so you can provide public comment, because the public comment period, again, as of May 2026, is currently open. There's a public hearing coming up, and so I'll leave information on that within the caption. So that's kind of the cadence of the 3 years from 2019, 2022, 2025 to here we are in 2026. And I'll explain more in part 2. But again, that's how the Clean Building Act was kind of born, how it exists today. It will be revised again, as Commerce is actually required to update the standard by July 1, 2029, and every 5 years thereafter. So there will be other legislative changes, also likely as this kind of process continues. So that's part 1, sort of the how did we get here. Part 2, we'll talk about what actually is the law. Stay tuned.